Welcome to the Supreme Court of the United Kingdom, where we are beginning the fourth and final day of the hearing of the appeals in the proceedings brought by the Financial Conduct Authority against a number of insurance companies. The proceedings are concerned with the extent, if any, of the liability of the insurance companies under business interruption policies to policyholders whose businesses were affected by the COVID pandemic. We're being addressed at the moment by counsel for the Financial Conduct Authority, Mr. Edelman, and I'll turn now to him. Mr. Edelman.
Morning. Good morning, Miles. There's a key point on the clauses that require something like prevention of access or inability to use. Sometimes it's expressed quite slightly differently, but if I can treat those two categories continuously. And that key point is, are they intended to require a total prevention of access or inability to use for pre-existing activities, or is some partial prevention or inability to use sufficient? And I was giving you at the end of yesterday the example of the restaurant with the access to the restaurant itself blocked. We can assume in this case physically blocked, although it's accepted by insurers that physical prevention is not required. But with the access to the rear leading to its kitchen, making that usable by kitchen staff. And so it was possible, therefore, to do takeaway meals and take them to the road for collection by a driver who could deliver the meals. The restaurant, for this purpose, we assume, hires drivers or enters into a contract with one of the delivery services to tide itself over. The answer that insurers give, they say if there was no pre-existing takeaway business, there is both a prevention of access and an inability to use, because those must be applied to the existing activities at the time of the event. If there was a pre-existing takeaway business, there is no prevention of access at all, or inability to use at all, because the continuation of that takeaway activity was possible. Nor could the restaurant recover the increased cost of working in respect of its additional delivery costs aimed at mitigating its loss suffered from the actual physical prevention of access to its restaurant, which meant that its restaurant area and therefore restaurant activity had to be closed. And that, in a nutshell, is, as we understand it, the insurance case. And that's why I said to my Lord Amlin yesterday that there is some overlap on some aspects of our case, but on this, it's an all or nothing. And there is actually a case of a cafe in Belfast that has, as far as I understand it, has been refused indemnity because they used to sell cakes to passers-by from a counter at the front of the cafe, and maybe hot drinks as well, I don't know. But the main business of the cafe had to close, but because the lady running the cafe could still sell the cakes and maybe a hot drinks, there was no inability to use, no prevention of access. And people like that are being refused any indemnity at all, even though nobody can go in. If the counter's at the front, nobody's allowed to go into the rear part to go and sit at the seats. And our submission is that these policies have to be construed and applied in a practical and purposive way. And it really does stretch credulity to say that in the two examples I've given, that there is no prevention of access or inability to use in such cases. And if the restaurant was to describe its activities in a proposal form or on the schedule to the policy, it might well put restaurant and takeaway. And one of those activities it's unable to use its premises for. It can't use the premises for the restaurant, and there is a prevention of access to the restaurant. For anyone wanting to dine in, they can't come and dine in the restaurant. And we would say that looking at that sensibly, one looks not just at all of the purposes of, well, if you can still do one of them, there's no inability to use or prevention of access at all. One simply says, well, there was an inability to use or prevention of access for that activity. And that, we submit, should be the answer to those categories of case. And it suggested, in relation to the prevention of access cases, that we've confused prevention with hindrance. And we say that hindrance is a different concept, and it's not, there's no conflict in our approach. Hindrance involves the idea of something being made more difficult. Cover against hindrance would cover a situation, for example, where a road closure meant that a long detour was necessary for people to access the premises, which would deter people from coming there. Prevention, whether partial or total, is not about making things more difficult, but about whether or for what purposes people are allowed to go to or enter the premises. And the same point applies to inability to use. Now, before I turn to the policies, can I also make some points about particular categories of business? Because there was some criticism of the fact that we didn't address in our appeal case how Regulation 6 on movement of the public affected categories 3 and 5. We didn't address that in our appeal case. And just to remind you, category 3 includes food retailers, pharmacists, but other things like hardware stores. And category 5 is businesses not mentioned in the 21st of March regulations or the 26th of March regulations. And that would include professional firms, accountants, lawyers, estate agents, and construction and manufacturing businesses. Now, category 3, we say they are unable to use their premises for their normal activities or their ordinary purposes, and there was a prevention of access because on the 16th of March, customers were told to stop unnecessary travel and stop non-essential contact with others. And Regulation 6 on later on, 23rd of March, customers were told only to shop for basic necessities. The prevention of access is like our example of a road closed, saved for residents or their visitors. In other words, you can only go to these shops for particular purposes. Like saying you can only use this road if you're a resident or you're visiting a resident. Otherwise, you cannot go there. You're not allowed to. And under the 16th March announcement saying that's what you ought not to do. Category 5, taking the professional services, generally they would be able to work from home. There would be no reasonable excuse to go to work if you can set yourself up at home. And so on that basis, you are unable to justify, and therefore unable to justify going to your business premises, and therefore unable to use them, and you are prevented from accessing them. And that would apply from the 16th of March announcement onwards, but obviously would include Regulation 6. We do in fact deal with it in our Respondents case in relation to some points made by Hiscox on their policy, which Mr. Gazeman didn't develop orally because of lack of time. Had he developed them already, I might have responded already and dealt with this in response to him. But the relevant passages in our submissions are our response case are 503, paragraph 503, that's B, tab 10, page 497, and paragraphs 516.1 and 516.2 at B, tab 10, page 502. I'm not asking to look at those now, but you'll see that we give some examples there of how it would all work. And there's, finally, I should mention category 4, non-essential shocks. It's the same point about restrictions on the public generally. But in particular, Regulation 5.1c required those premises to cease to admit any person to the premises not required to carry on its business or provide its services, essentially remote sales. So if you were a shop, you had to close your doors to customers, but your staff could continue to work on remote sales if that's what you were doing before, or if that's what you wanted to start doing. If that's what you wanted to start doing, there is a prevention of access or inability to use. But if you were doing some of that before, then there is no prevention of access, no inability to use, according to insurers. We say that defies a common sense construction and application of these policies and undermines their commercial purpose. So, my lords, if I can now move on to the art policies, just to mention that I have until 11:17 because we're splitting a 5-minute break between the parties, and then Mr. Lynch will have his 40 minutes. So I'm with hard negotiation. I think I may have lost 30 seconds, but so yeah, probably just wasted it by telling you that. The art policy. We can probably take these now quite quickly, and the intention of dealing with taking some points generally was to avoid repetition when I got to the policies. If we go back to Bundle C, tab 4, page 227, the prevention of access clause, the judges below dealt with this in the judgment at 324 to 336. The long passages, I hope you've read them. I'm not going to reread them. Just to pick up some of the points that are made in response, reliance, if you go back to the previous page, reliance is placed on extension 1, hinders or prevents access. And it said, well, if it meant hindered access, it would have said so. For the reasons I've given, that misses the point. We're not talking, I'm not trying to turn hindrance into prevention. It is something different, but partial prevention is not hindrance, it's partial prevention. And reliance is also placed on the disease extension at on the extension at extension 3 under disease on page 226 still, and at the foot of that extension, which it doesn't apply because there's defined diseases. If you want to go back to 224, you'll see this is one of those examples where they listed the diseases that the policy should apply to. Just if you're interested, but it's not on this point. Going back to 226, it said, well, this talks about use of the premises being restricted, and if in the extension we're concerned with, number 7 on page 227, if it had meant use, it would have said it, but it says prevention of access. I agree. That's why we focused our submissions on whether people are allowed to go to the premises and whether, after Regulation 5, the shop was allowed to let people in. And the answer was it could only let in those people who were working there in order to work on remote sales. It couldn't let in customers. And that was a prevention of access to customers. It may also have been the fact that there was an inability to use the premises for in-store sales, but it is also prevention of access. But one point that does support our submissions, and that is, although it's not, I don't place enormous weight on it, but it's a factor. At page 226, going back to that, the preamble, we have reference to reduction in turnover and increasing cost of working. And if you go to the definition of turnover on 225, it's money paid or payable to you in the top left-hand corner in the course of the business at the premises. And we've got the definition of gross profit, indemnified in respect of interruption or interference from the business as a result of damage occurring in the period of insurance. Basis of settlement on the next column, insurance of gross profit is limited to loss due to reduction in turnover and increase in cost of working. But it seems to be the case from Arch's perspective that when it comes to this prevention of access clause, unless your increasing cost of working is incurred after the prevention of access has ceased, perhaps, or in order to start up a new activity, you don't get indemnity. This simply doesn't apply to a business. In my example, remember I gave the example of hiring extra drivers or engaging the service of a delivery company at increased cost in order to reduce your loss of turnover resulting from the closure of your restaurant. That is not recoverable as an increased cost of working. And again, we say that just it doesn't make sense of what a policy appears to be conferring on the insured as a benefit. Similarly, it said because in relation to office staff, because people could go, the IT staff could go in and you could have your printing department going, there wasn't a prevention of access. But those are, accepted that those are peripheral activities, those are not fee-earning activities. But if you hired more IT staff, as so many people have done, so that the fee earners, the business itself, the profit-earning element of it, could continue with all the fee earners working at home, that is not an increased cost of working. Because the fact that people from IT can go in there to look after your server and make sure everything's working is just demonstrates the case, as I understand what insurers are saying. It demonstrates the fact that access is not prevented. And that is what I wanted to say about the Arch policy. I should perhaps, before I go, just show you, before I go from that one, show you a passage in the judgment at 310 where a concession is made, paragraph 122. Sorry, it's page 122, paragraph 310. under C, of course. And you'll see the concession there recorded. It's about just the end of the third line. Arch also accepts that where the effect of the actions or advice was that the business had to close or cease business, there was a prevention of access. In other words, it was not necessary that access be physically impossible or obstructed. And then the next sentence down, Arch accepts that there was a prevention of access for businesses in category 2 in relation to category 1, which did not previously provide takeaway services. Access was prevented because they could not be open to customers without the policyholder making a fundamental change to the nature of the business. And that was the limit of the concession. That's where I got that if there's an existing takeaway, then you lose. Sorry, the one further point I should have made about Archie's case, they've said that the extension requires the prevention of access to be directed at the means of accessing the premises. So although he says it's not about physical access, they do take a point that restrictions on the movement of people, free movement of people generally, is not a prevention of access. But we submit that's not what the provision says. It just requires that the actions or advice of the government have the causal consequence due to, have the causal, going back to page 227, the prevention of access must simply be due to the actions or advice of government, and that causal connection is satisfied if the effect of the government action or advice is to prevent people from going to the premises, whether it's to a shop, a restaurant, or a professional person going to his or her office. And so, my lords, I move forward to Hiscox, and Hiscox 2 and grounds 2 and 3 we have on this one. Can I just show you perhaps Hiscox 2 at tab 7 in bundle C, page 430. And you'll see that the restriction is inability to use due to restrictions imposed. I've made my submissions about restrictions imposed. Question whether imposed requires legal force. We say not. Imposed is what the government was seeking to do in its announcements, but we debated that yesterday. So the question that I want to address is inability to use, and I've again made some submissions about that, but just a particular example, because we're on inability to use as opposed to prevention of access. Let's say that because of a problem with drains or sanitation, the owner of a 2-story department store decided that it wasn't going to be possible to have customers in the ground floor, but they could still use the second floor. And so people could still go and shop on the second floor. According to Hiscox, there is no inability to use at all, because you can still use the second floor, even though they would have no quibble with the fact that there is actually an inability to use the first floor. They say it's not a qualifying inability to use because you have to be unable to use the premises in its entirety, and hence when we come to use my case about the lady running the small cafe, because she could still use the front part of her shop to sell cakes and maybe the odd hot drink, there was no inability to use, even though all of the property to the rear, though she was unable to use it because she was not allowed to serve in there and people weren't allowed to come in. And if we look at some of the elements in the clause, in the clauses, firstly, if we go to page 430, you'll see that this also has increased cost of working, and it also, at the foot of the page, has uninsured working expenses. And you'll see one of the uninsured working expenses is rent. And if you go to the definition of the word rent, you'll see it's defined as rent for the salon that you must legally pay whilst the salon or any part of it is unusable as a result of insured damage or restriction. And in this form of policy, the only clause that imposes a restriction on page 431 is the public authority clause, inability to use. And we submit that that demonstrates that Hiscox contemplated, and the policy contemplates, part of the premises being unusable, which we say is right, albeit not the sole extent of the inability to use. This one is a very simple policy, but there are others. One point is made when we relied on the additional cost of working. It said that this only applies during the indemnity period, and as I said, the indemnity period could extend beyond the lifting of the restrictions. But the indemnity period, you'll note on page 430, starts with the date the restriction is imposed. So there is no reason to conclude that increased cost of working only applies after the restriction ceases to be imposed, and it would be counterintuitive for it to do so, because it's imposing, it's saying to the insured, don't worry, if you mitigate your loss, we will pay for your costs in doing so. It defies belief, we submit, to say that if an insured incurs costs to diminish its loss, that actually could result in it losing cover, but in any event, it's not covered for it in circumstances where it is unable to use part of its premises and incurs costs to reduce the loss as a result of doing so. One can also see that in other forms of the policy, I think there is this in Hiscox 1, page 400. There is a reference to bomb threat, and that's about in the middle of the page, an extension for bomb threat, and you'll see that that refers to total inability to access total access is denied. And so we submit that that is an indication that the draftsman of these sets of clauses, and I know I've just shown you two separate policies, but these are all you'll see from all the different policies that there are sets of words that Hiscox uses, and one is entitled in my submission to form a judgment as to what an insurer intends as to the operation of its policies from viewing its suite of clauses, and that is how this all fits in. It also, if we go back to page 431, there is a, if you look at the loss of income at the first item under how much we will pay, but in the bottom quarter of the page, loss of income, the difference between your actual income during the indemnity period and the income it's estimated you would have earned, which again is consistent, or certainly not inconsistent, with the contemplation that despite the inability to use, there may be some income still being generated. You'll also be aware that the court construed interruption, still on page 431, the top of the page, as encompassing interference and as covering the normal range of things that a business interruption policy would cover. Hiscox appeal against that, but on the basis of the judgment, that's broad. But on the basis of the approach to inability to use, it would only apply to the most extreme interruption, complete cessation, and would not be consistent with the more general meaning of that word as the court gave to it. Yes, Mary.
Sorry to interrupt you, Mr. Amlin. I just wanted to mention now that I have some questions I'd like to ask before you finish about wide area damage again. So I'm just inviting you, if you wouldn't mind, to leave a few minutes at the end.
I will. I will, certainly. Yes. Yes. I'm trying to take this quite quickly because it is fairly fully set out in our case, but I'm just trying to meet some points that have been addressed. I think we've dealt with the your activities, your business point. It's said by Hiscox specifically, and this is paragraph 107 of their response to our appeal, if an insured adapts after a period of being unable to use, it will be able to claim for both a period of inability and the increased cost of working within that period. But it simply doesn't address the argument that if there was the ability to adapt to use the premises in a way which makes it possible to carry on the business in a fundamentally different way, the inability to use must be looking at some particular pre-peril activity, and that means that the premises were still able to be used. By definition, if you can adapt to use it for something else, you were able to use the premises. So there is an inconsistency in the argument in saying, well, if there's no inability to, we're not saying you cease to be unable to use it if you can use it for something new. Well, if you can use it for something new, why should it be an inability to use if you continue to use it for one of two purposes that you were using it before, but not the other? My lords, RSA 1, which is at page 1129, It's closure or restrictions placed on the premises as a result of a notifiable human disease. Closure or restrictions placed, and it's a question there whether indirect measures suffice. And we say the correct reading of this is closure of or restrictions placed on the premises, and that is in fact how the court read it. You'll see it, paragraph 294. But we submit that on this one, that if there is a closure of the premises, that as we've said in our case, that can be a closure which is, all it has to be is caused by. So what you're asking is, has there been a closure of the premises as a result of, we accept accepting that there has to be something, some sort of, some reason associated with the disease for the closure, but a closure either because people are not allowed to come to the, are not coming to the business anymore, or because people are not allowed to come to the business anymore, would be sufficient. So even if there were premises that weren't ordered to close, if they had to close because of the circumstances, then that would be covered. My lords, the remaining policies to address are all policies where either we succeeded on other grounds in relation to RSA 4 and Amlin 1 and Hiscox, or we failed, but what we are doing is testing, because this is a test case, asking for a particular provision, a particular declaration, if it's going to be altered consistently. So I'd rather answer my Lord Legate's question than deal with those which are less significant points.
Yes, thank you, Mr. Edelman. I've just been reflecting about the wide area damage problem that you addressed us on early on, and Orient Express hotels. And I've just been wondering whether there are perhaps two different aspects or questions which may at some points have been conflated, but which need to be kept distinct. The first is illustrated by the case where the hotel is badly damaged, so is the surrounding area. The hotel has to close for 2 weeks, but even if it had been open, nobody would have come to the hotel because they couldn't access it and the surrounding area was devastated. And you make the point, which I entirely understand, is that if one applied a simple but-for test, the claim would fail because you wouldn't be able to say that but for the damage to the hotel, the loss would have been suffered, because it would have been suffered anyway. And one shouldn't allow the claim to be defeated because there's another sufficient concurrent cause. But let's now consider a separate situation. Suppose that the hotel, because it's perhaps in a sheltered position, it gets off quite lightly with not very much damage compared with most of the surrounding area. And after a week, it's able to open again, although perhaps it's still got some damage. The top 2 floors are out of action, but the rest of the hotel is functioning. But nobody comes to the hotel because the surrounding area is damaged, or hardly anyone comes. Now here you can't say that but for the damage to the hotel, the loss would have been suffered anyway, because it wouldn't. Here the loss is caused not by the damage, or part of it, not by the damage to the hotel, but only by the damage to other properties which are not insured. So how, on your case, do you adjust that loss?
That is actually precisely the scenario that is posited in the textbook example that I showed you, because he said the hotel and the access bridge are damaged, and the diagram may have been difficult to understand, but what he was saying is during the period of closure, which is referable to the damage, you essentially say you've got concurrent causes of the fact that you can't have any customers, and you pay out ignoring the wide area damage. You then come to the post repair period, and if you remember that the text there was explaining you do still have to make the assumption that in normal circumstances, if you've been closed for a week, it might take you some time to recover your full clientele, because the word might go around, oh, it was damaged by a hurricane, and people might be put off. So what was being said in that text as an example, and I can't do better than that, was you then have to, you accept that there wouldn't have been any customers anyway because of the wide area damage, but you don't in those circumstances say zero. You don't say, well, once it's reopened, it wouldn't have had customers anyway. You say in the normal world, let's say in the week afterwards, it would have had 50% of its normal capacity. And in week 2, it would be back to its 100% normal capacity, because it would have done an advertising campaign. We're open, we're back in business. Miraculously, we were only lightly damaged. And so you would compensate them for the 50% loss in the week after the damage, because that's what would have happened in the normal world. But you do not compensate them for the extra 50% on the basis that they did reopen, but there was nobody there because of the wide area damage, because then that would cease to be indemnifying them for the damage. You would only be indemnifying them for the wide area damage, which on this hypothesis is not insured.
Yeah. I think what you said may coincide with what I was thinking about this, which was that maybe in the Orient Express Hotels case, both parties were arguing for a wrong position. One side, the insurers, were saying you compare damaged hotel in damaged city with undamaged hotel in damaged city, and that was, one could see the objections to that. But the insured was saying you compare damaged hotel in damaged city with undamaged hotel in undamaged city, and that also has its problems.
Yes.
It seems to me maybe the correct analysis is what you compare is undamaged hotel in undamaged city with damaged hotel in undamaged city. In other words, you assume for the purposes of the adjustment that the city hasn't been damaged, and you look in terms of what last year's turnover was, let's say, updated for trends, and then compare the two alternatives with the hotel within that. Is that possibly a way of looking at it?
Yes, my lord. And that, if you reflect on what is actually being done by doing that, what you're doing is taking out the hurricane for all purposes. You're taking out the peril for all purposes. And insurers have misunderstood with respect to them what we're saying about that. Because when we say, well, you take COVID out, they're saying, oh, that means Mr. Edelman wants all the indemnity for all the effects of COVID. Was the answer I gave to my lord, I think it was my Lord Briggs. That's not the point, because here we're on the adjustment, and it's the point about when you're looking at that post repair period. When it's closed, it's 100%. But when you're looking at the post repair period for loss of turnover, you are looking at, well, what would have happened in a normal world with no hurricane anywhere? You would have got 50% of your turnover. You in fact got 0. So we are going to give you 50%. In fact, you got, and you can't say you would have got 100% from being you can't claim more on the basis of the non-existence of the hurricane. When you come to all other losses and say, well, you say, but I didn't just lose 50% of my revenue, I lost 100%. I said, well, no, that's not the answer. That's why I said also one of the difficulties with the Orange Express is that it was an arbitration decision. So we don't really know how the case, we don't know, the public don't know how the case was actually argued. We don't have the full award in the judgment. And of course, on appeal, the approach to the judgment is conditioned by the way in which the case has been argued and therefore decided, because there has to be an error of law in the decision. And the decision itself is driven by the way the case is argued. And with respect, we say that the answer is to be found in that textbook, which actually explains how it should be done. I think I've got 1 minute left. It's probably not even, I'd maybe just have a quick look at RSA 4, enforced closure. It's at 1321. Just to point out that the real question here, no real additional question, it's whether enforced it's at the top of the page in the right-hand corner, whether the word enforced makes any difference. We say no, it's still something that you didn't do voluntarily. You were forced to do it, but that doesn't mean legal compulsion. It just means you didn't wake up one morning and decide, I don't fancy working today, I'm going to close the shop. You were forced to do something you wouldn't otherwise have wanted to do. And otherwise, for the remaining policies, I will have to do as Mr. Gazeman did for some of his grounds for want of time, to rely on our written submissions, but in the comfort at least that by and large they are provisions on which are not actually material to the outcome for policyholders on those policies, albeit that the principle is important across the board generally. But they raise very similar points to other points in the case. Well, those are my submissions, and I think it's 11:17 over my time to be quiet.
Thank you very much, Mr. Edelman. We turn next then to Mr. Lynch, representing the Hiscox Action Group. Yes, Mr. Lynch.
My lords, good morning. It seems that my camera has decided to go on a voyage of its own, which I hope I can repair. My lords, I hope that's satisfactory.
Yes, that's fine, thank you.
My lords, thank you. My lords, as you're aware, I appear for the Hiscox Action Group with the perhaps regrettable acronym, the HAG. Acting as I do for real policyholders, I would like to extend our gratitude to the court and the court staff for holding this hearing so remarkably quickly and efficiently. We are very grateful. I have the unenviable task of following my learned friend, Mr. Edelman, and attempting to add to, rather than detract from, his submissions. My allotted time is 40 minutes. The HAG has 3 grounds of appeal, and Hiscox has 8 grounds of appeal. It will not realistically be possible for me to address all 11 grounds in 40 minutes. And in respect of our appeal and Hiscox's appeal, both their oral and written submissions, I therefore adopt our written case and our responsive case together gratefully with the FCA's written case and responsive case and the oral submissions of my learned friend, Mr. Edelman. If we could please turn to C3410, which is the public authority clause in Hiscox 1. This is the centrally important clause for the HAG, and in fact the basis for all claims put by them.
Could you give us the page number again, please, Mr. Lynch?
Yes, so it's Bundle C, tab 3, page 401.
Oh, yeah. Yes, fine. Thank you.
Thank you. It's clause 13. And I intend to focus on three topics. First, 3 points on how to go about construing the clause. Secondly, our third ground of appeal, addressing your inability to use the insured premises wording. And thirdly, to the extent that there's time, some very brief comments on the due to restrictions imposed by a public authority wording. Now, I will attempt to avoid overlap with Mr. Edelman, but it will be inevitable that there will be some. And if I could just make one obvious first point, which is that it has been necessary for the purpose of rationalizing the parties' various grounds of appeal to break up the public authority clause into phrases or even single words. Of course, that is not the correct approach to construction, and the clause must, of course, be read as a whole. So if I could turn, please, to 3 points on the approach to construction. Whilst all parties to these appeals cite largely the same authorities on construction, as was the case below, profess to be applying the same principle, the way in which Hiscox has done so, we suggest, invites a critical examination of whether there are in fact important differences of nuance that have emerged in the process of application, but which have an overarching impact on the parties' approaches to the specific issues of construction, articulated in their grounds of appeal. In that respect, we draw attention to 3 points that we submit are of assistance in relation to each of the Hague's and Hiscox's grounds. First, the role of foreseeability in the construction of policies of insurance. Second, the meaning of the reasonable expectations of the parties. And third, the point that these are simple policies. So on our first point of construction, the role of foreseeability in the construction of policies of insurance, on the Hiscox wordings, it is wrong to suggest that in the present context, the nationwide pandemic and government's response were not within the risks which the parties objectively contemplated. But in any event, the correct approach to the law on this issue of foreseeability is, we propose, as follows. And I have 5 points here. So first, please could we go to C6402, so 1 page on from where we are, and we see in clause 19, 1.9, this is a clause to which my learned friend Mr. Edelman has already taken your lordships. This is the cancellation and abandonment wording, and in particular Roman numeral 3, which your lordships may recall reads as an exclusion for any action taken by any national or international body or agency, directly or indirectly, to control, prevent, or suppress any infectious disease. Now, this wording appears in Hiscox 1 lead, Hiscox 4 lead, and Hiscox 4 variant with NDDA clause. And the obvious point to draw from this is that on this wording, the draftsman had well in mind and foresaw the possibility or probability of A, a pandemic or epidemic, and B, any action taken by any national, international body or agency, directly or indirectly, to control, prevent, or suppress any infectious disease. Second point under this heading is to refer to the factual matrix. Now, I won't go over the ground that my learned friend Mr. Edelman has already gone over, but that appears at paragraphs 28 to 31, G5, 11 to 13 of the FCA's skeleton for the first instance trial, and also was addressed by my learned friend Mr. Edelman, draft transcript, day 3, page 5, lines 4 to 20, and pages 13 to 14, when your lordships will recall that my learned friend addressed the examples of SARS and the 1987 storms. It is also right to note that the public authority clause in the Hiscox wording refers to notifiable diseases, rather than, as some insurers do, a closed list. And Hiscox is inherently thereby allowing for new diseases, i.e. building in unforeseen or unforeseeable diseases. Third, under this first point of construction, we would refer to the guidance given by my Lord Justice Legate, as your Lordship then was, in the Equitas case, which appears in relevant part at E 14266. And if I could invite your Lordships, if it's convenient to go to that, please. This is paragraph 159, where my Lord was quoting from, addressed this issue and also quoted from the judgment of Lord Justice Chadwick in the Bromerin case. And reading the passage at 159, true it is that the question whether a term must be implied is to be judged at the date when the contract was made, ... and that when the relevant reinsurance contracts were made, the parties could not have foreseen the situation that has arisen as a result of the law's response to mesothelioma claims. The court's task is nevertheless to consider how reasonable parties should be taken to have intended the contract to work in the circumstances which have in fact arisen. And then, quoting from the Bromerin case, the task of the court is to decide in the light of the agreement that the parties made what they must have been taken to have intended in relation to the event, which they did not contemplate. That is, of course, an artificial exercise because it requires there to be attributed to the parties an intention which they did not have as a matter of fact, because they did not appreciate the problem which needs to be addressed. But it is an exercise which the court's been willing to undertake for as long as commercial contracts have come before them for construction. Now, although my Lord Legate's comments in Equitas were made in the context of a question about the implication of a term, we do not understand the proposition your Lordship expressed to be anything other than an uncontroversial statement of the court's approach to construction generally. And indeed, Lord Justice Chadwick's comments in Bromerin arose in the context of a question of construction of a clause rather than the implication of one. It is also relevant to note that in the sentence immediately preceding the part of Bromerin that my Lord Legate quoted in Equitas, Lord Justice Chadwick also said this. If we could go, please, to F for Foxtrot, tab 10, page 148, we see there a passage in the Bromerin case at G. And at G, my Lord Justice Chadwick stated, it is not, to my mind, an appropriate approach to construction to hold that where the parties have contemplated event A and they did not contemplate event B, their agreement must be taken as applying only in event A and cannot apply in event B. That approach, which Lord Justice Chadwick describes as inappropriate, is, with respect, precisely the approach we suggest Hiscox has adopted in relation to these questions of construction. Hiscox's reliance on the statements of Sir Thomas Bingham, Master of the Rolls, in the Phillips case at G771556, I don't propose we go to that, can be quickly dismissed. That relates to a different issue. The implication of a term was what was relevant there, and the correct warning to the court not to come to the task with the benefit of hindsight and fashion a term which reflects the merits of the situation as they then appear. However, your Lordships are not being asked to imply any term. This is simply a different situation. And it's a different situation as a matter of principle, because as Sir Thomas Bingham held at page 481, G771555, the implication of contract terms involves a different and altogether more ambitious undertaking. The interpolation of terms to deal with matters for which ex hypothesi the parties themselves have no provision, it is because the implication of terms is so potentially intrusive that the law imposes strict constraints on the exercise of this extraordinary power. Our fourth point under this first point of construction is that insurance policies, just like any other contract, are never going to describe with perfect specificity the events that trigger cover. Instead, what they do is categorize risks in ways that leave a large scope for those risks to materialize in unforeseen ways. that insurance policies operate in this way is part of their nature and part of why they are commercially successful. There is much variation in how events occur in life, and that range of potential fact patterns must be caught by insurance policies, if they're to operate at all, by describing cover in a way that allows for such flexibility. Our fifth and final point under this first heading is that it is important not to confuse two different questions. One, what is covered? And two, how did that covered risk eventuate? Absent an express exclusion, the question of whether 2 is foreseeable matters little if the risk is within the scope of the clause. I'd refer here to a case with memorable facts. My learner, I'm sorry to interrupt. I suppose I'm interrupting my own flow, but I see my learned friend, Mr. Edelman's turned his video off. I'm grateful. I'd refer here, sorry to break off in that way, but I'd come back to the case I was going to, which is Harris and Poland, which appears at Bundle H, Tab 1, Page 1. And it's a case with memorable facts, which I refer to by way of example. And the short point is that where damage was caused by fire and that was covered, it was unimportant, the way in which the damage caused by the fire eventuated. And whether or not that, what was unimportant was that the way that the fire eventuated was foreseeable or not. So to explain that by reference to the facts, this was a judgment of Mr. Justice Atkinson concerning a claim under a fire policy. In that case, the insured placed jewellery for safeguarding in a fireplace, hidden under coal and wood. When she returned, she went out, when she returned, she forgot this and lit the fire, causing damage to her jewellery. She made a claim under her policy, which insurers denied. The language of the insuring clause, of the relevant insuring clause, was in broad terms and stated that cover was provided against loss or damage caused by fire. And that the court's references at H1.3, the plaintiff straightforwardly submitted that her loss fell within that clause. Now, one way of characterizing the insurer's arguments, which we don't have time to go to in detail, at page 465, which is H1.4, the insurer's argument could be characterized as saying that the way in which the risk eventuated, namely the damage caused by fire, was unforeseeable, because nobody would have thought that damage caused by fire in a place where fire is supposed to be would be covered. And nobody would have thought that someone would hide their jewellery in the fireplace and then set fire to it. But that argument was rejected, rightly, by Mr. Justice Atkinson, who found for the plaintiff. In an approach which we suggest entirely consonant with the modern approach to construction, Mr. Justice Atkinson began by considering what the simple words of the policy would mean to the ordinary man, and held that there was no basis for reading into those ordinary words a limitation that is not there. Now, refer your lordships to pages 466 to 468 of the report, which are at H1, 5 to 7. We don't have time to go to those now. So those were our points on foreseeability. Our second heading on points of construction generally is as to the meaning of the reasonable expectation of the parties. Now, here we seek with respect to develop and expand upon a comment made by my Lord Reed at draft transcript day 3, page 112, line 18, to day 3, page 113, line 13, and Mr. Edelman's responses at pages 113 to 115. My Lord Reed comment was about how it is relevant to the interpretation of the trends clause that insurers' construction incentivizes insureds to ignore government advice issued in the interests of public safety and thereby encourages socially irresponsible behavior. My Lord commented that one has to interpret the contract to reflect what one would reasonably to take the party's intention. Sorry, I've misquoted that. So one has to interpret the contract to reflect what one would reasonably take to be the party's intention. And that's draft transcript, day 3, page 113, lines 11 to 13. Now, our general point here is that what one assumes the party's intentions to be is grounded in community values, and this chimes with my Lord's point about discouraging socially irresponsible behaviour. The authority in particular is the article by my Lord Steyn, Contract Law, Fulfilling the Reasonable Expectations of Honest Men, at H2:16, which was endorsed by the Supreme Court in Rainy Sky at paragraph 25 in the judgment of my Lord Clark. Now, I won't go through the article in detail, obviously, but briefly, the relevant points are these. The notion of reasonableness in this context is neither abstract nor technical, but is to do with what Lord Steyn describes as community values. It is concerned with contemporary standards, not of moral philosophers, but of ordinary right-thinking people. That's page 1 of H2:1. The reasonable expectation of the parties takes its distinctive colour from the context of the transaction, and the Hague submits that the following facts are relevant. 1, that the insureds are SMEs. 2, with low levels of sophistication as purchasers of insurance. 3, low levels of indemnity. And 4, the off-the-shelf nature of the policies. Further, the fact that these are all businesses in the real world, many in public-facing forms of enterprise, and for very good reason, and obvious reasons, strongly indicates that the parties would expect compliance with government statements, whether or not they technically had the force of law when given. As my Lord Reid put it, one has to interpret the contract to reflect what one would reasonably take to be the party's intention. This is particularly relevant to the restrictions imposed wording, but also obviously relevant to the inability to use wording, which must follow from the restrictions imposed. The reasonable expectations of the parties is also consistent with taking a purposive rather than literalist approach to construction, the approach which best gives effect to the reasonable expectation of the parties is one in which dictionaries are generally of little help. The commercial purpose of the contract is more important than niceties of language. Our third and final point on approach to construction concerns the simple nature of these policies. Our proposition is that these policies should be construed in a straightforward and uncomplicated way. Please see paragraph 8 of our written case B380. Why does this matter? Because Hiscox's approach to the construction of the application and application of the clause results in various respects in extremely complicated, indeed unworkable complexity, when these are meant to be commercially realistic and readily applicable policies, capable of straightforward application in everyday scenarios. With low limits of indemnity and not much time or money being spent in their mundane application. In particular, this is a point of most obvious relevance to the counterfactual. The parties cannot objectively have intended a counterfactual which could never have existed in the real world. For example, depending on how my learned friend Mr. Gazeman puts Hiscox's case, the nail salons issue, which would be likely to give rise to complicated issues on application and the adjustment of claims, even if that is possible on Hiscox's approach. These are complicated and expensive issues that small insureds are often unable to afford to pay. And if my learned friend Mr. Gazeman, with his references to the arbitration and to the ombudsman, inadvertently gave the impression that all of this is going to be very easy, then that would, in the Hague submission, be a false impression. This would not be easy. This would be complicated and expensive and inappropriate for this kind of policy. We would submit this position is supported by 5 points. First, this is supported by Hiscox itself at paragraph 6 of its reply submissions, B14551, where Hiscox describes as not controversial that the policies should be comprehensible, clear, and readily applicable in the real world. Second, it is supported by the wording itself. C6374, this is the introductory wording to many Hiscox policies. We hope that the language and layout are clear, we want you to understand the insurance we provide. Third, it is further supported by the judgment of my Lord, Lord Hodge in Wood and Capita, G 94195, at paragraph 10b and 13, and 12 and 13 at C and E. This is just a consequence of general principles of construction. Fourth, our position is consistent with Lord Staines's analysis of the reasonable expectation of the parties, which places emphasis on 1, what words mean to the ordinary speaker of English, 2, the role of community values in understanding the reasonable expectations, and 3, the importance of the nature of the transition in giving those reasonable expectations, the importance of the nature of the transaction in giving those reasonable expectations their, quotes, distinctive colour. Fifth, and finally on this point, it is supported by the approach and reasoning in Harris and Poland, which we've seen. That brings an end to our points on construction. Obviously, those points are intended to apply by way of general application and not simply limited to the Hague's grounds 2 and 3, which I now go on to address. Turning now to our ground 3, our third ground of appeal is, in summary, that the court took, with respect, an unduly narrow approach to the inability to use wording. And if we could please then go back to Bundle C, page 401. At clause 13, there we see again the public authority wording. Now, there are 6 overarching points relevant to the proper construction of inability to use. The first point goes to the natural and ordinary meaning of the term inability to use. The short point here, and the short answer to a lot of Hiscox's arguments on this issue, is that it is common ground that inability to use the insured premises means asking, can the insured use its premises for its business activities or not? And one sees that that's common ground at, for example, there are lots of examples, but one example, paragraph 80 of Hiscox's reply submissions at B14571. Now, Hiscox asserts that this is a simple binary question. One can see that that cannot be right with respect. The real problem for Hiscox here is that as soon as one introduces the qualification of for its business activities, the question goes from being allegedly binary to obviously not binary. The for its business activities qualification, which is common ground is correct, adds an immediately qualitative, fact-sensitive and purposive meaning to the clause, which can only be answered by looking at the facts of individual cases to determine whether or not the insured can use its premises for its business activities or not, which will necessarily include a wide range of factors specific to each insured and the nature of their business. But what are the insured's business activities? Now, my learned friend Mr. Edelman has addressed you on this already. It means their normal business activities. This will be in part evidenced on the face of the policy schedule, as my learned friend Mr. Edelman has already said. For example, C6360, the insured is a bike repairer and retailer. But obviously, the schedule only takes one so far. The real answer will depend on the true facts of any individual case. Why add the qualification of asking what are the insured's normal business activities? Because that is the true question. It is inherent in asking, what are the insured's business activities? Of course, this will depend on the facts because some businesses do multiple things. If a dine-in restaurant can only function as a takeaway, that is not using its premises for its normal business activities. If the gunsmith, gun retailer, which is Hiscox 3C8433, can only use its premises to answer the telephone about gun upkeep, then the gunsmith is not using its premises for its normal business activities, i.e. actually repairing, modifying, and building guns. Here, partly unable means unable. in the context of a business ensuring the ability to use its business premises. Further, a necessary element to assessing whether the insured can use its business premises for its business activities or not involves a quantitative assessment of the position on the facts. In other words, pulling those two elements together, a sliding scale of whether the insured can use its premises for its business activities or not in terms of 1, the volume of work done, 10% or more, 2, the nature of the work. Is the dining restaurant now only a takeaway? But these questions of fact and degree are not difficult or so complicated as to be unworkable. They are simple questions of fact, which the courts and arbitrators are well used to addressing and are simply answered in simple, low-value cases, and which adjusters have been doing for, of course, many years. Whether or not an insured can use its premises for its business activities is not a binary question. It is only capable of the answer completely unable to use the premises or completely able to use the premises, contrary to what Hiscox contends in its reply submissions, paragraph 80, B14, 571. If we take just one example, this is a golf club example, which appears at example 6 of our written case B3100, the insured is a golf club which consists of a golf course and a clubhouse which serve food and drink, alongside hosting events and conferences. The entirety of the business was shut following the imposition of Regulation 4.4 on the 26th of March, although the business was permitted to have groundskeepers on the premises for the maintenance of the golf course. Following the governor's announcements and guidance given on the 13th of May, the business was permitted to reopen its golf course, but the clubhouse had to remain shut. This resulted in a severe dip in the number of customers. Here, on reopening, plainly the insured was unable to use the clubhouse and suffered business interruption and loss, and thereby loss. But the ability to use the golf course would, on the court's approach, have been more than vestigial, and therefore there would arguably be no recovery. This, with respect, indicates that something has gone wrong with the court's approach, particularly if one posits the further example. What if they were different businesses? One could recover, but one couldn't. Now, our second point under this ground 3 is that contrary to other wordings in the policy, the word inability does not denote the specific extent to which the insured lacks the inability to use. It does not suggest that the insured must be completely unable to use the premises. Now, my learned friend, Mr. Edelman, has already taken you to the bomb threat clause. That's clause 4, C6-400, which refers to total inability to use. And also, I believe my learned friend took you to, but in any event, clause 3, the NDDA clause, C6-400, an incident which results in denial of access or hindrance in access to the premises. Hiscox's responses are interesting. They say in paragraph 97, B14.577, they argue that the use of the word total in the bomb threat clause is readily explicable because when compared to the hindrance in the NDDA clause, it reflects the party's desire to make clear that only if there was no access at all would the clause bite in the case of a bomb threat. Our simple response is that this contradicts Hiscox's own case. If, as Hiscox argues, the word inability naturally denotes total inability, then there would be no need to include the word total in the bomb threat clause in order to differentiate it from the weaker requirement of hindrance, as this, my Lord Legate.
Just reflecting on your point about it, whether it's binary or not, I can see your argument. Perhaps the answer is, in a way, it is binary, but it depends how you're looking at the clause. I can see your argument that if you can't use the premises for a particular discrete activity, or if you can't use part of the premises, then you can still come within the cover. But on the other hand, let's suppose that you can use the premises, but many fewer people can come in because you have to, or you are observing social distancing, and so you ration the number of people who can come in. You couldn't say that that was an inability to use, could you?
Well, my Lord, the answer will be a matter of fact and degree in each case. And the answer will be, depending on the facts, an inability to use to the extent of the inability. And obviously one difficulty is talking about these issues as a matter of in purely hypothetical terms. But it doesn't take much for one to recognize that a business is only made up of employees and customers in large part for these kinds of businesses. And there may be a point that comes where it becomes clear that enough of a downturn is suffered by enough of a percentage of employees / customers being unable to attend for it properly to be called an inability to use. And that will be, as I've said, a quantitative and qualitative assessment. But it would be wrong in principle in my submission to say that across the board, because some people can attend, it's not an inability to use.
Thank you.
My Lord, our third point under this heading is that excuse me, our construction is supported by subclauses A to E, and this is just a very brief point looking at clause 13 itself. Here, Hiscox makes the point, well, look at subclauses A to E, page 401. It's likely that there'll be a complete inability to use because of those. Well, no, it's equally likely that there'll be a partial inability because a flood might affect one part of a property or one category of work being done. It's not a complete inability that must follow. Our fourth point is that the surrounding clauses in the Hiscox policies support our construction. Now, my learned friend, Ms. Edwin, has addressed these, so I'll just do these briefly. We see at C6 403, the loss of income wording. Please see an example there. We will also pay for increased costs of working and alternative hire costs. And then also the definition of increased costs of working itself appears at page 399. The costs and expenses necessarily and reasonably incurred by you for the sole purpose of minimizing the reduction in income from your activities during the indemnity period, but not exceeding the reduction in income saved. Here, the clause is obviously envisaged working in the present tense. It seems clear that these clauses, the policy itself, envisages, for example, alternative hire costs at 399 as well. The business continues. So it's, to take my Lord Legate's point, it's envisaged by the policy wording itself that there is a continuation in the business. The question is there sufficient on the facts for it to be called an inability to use? And if so, on the facts, what form does that take in each case? Hiscox relies on the definition of indemnity period, which appears at 399, and Hiscox argues that that the word restriction there means only restriction. It does not stand in for the full insured peril. That is, with respect, wrong for the reasons we address in our written case, but is also contrary to the judgment, where it's made clear that where there's reference to restriction, it means the insured peril. That can only be right, because otherwise the indemnity period would commence when there isn't an indemnity. So restriction must mean insured peril, which takes away from Hiscox's argument at this point. There's also at page 378, if I could go to that, please, of the policy wording, there's an obligation on the insured to take every reasonable step down at the bottom. Sorry, it's down at the bottom of the page, at page 378. Your obligations, excuse me, at clause 2A, you must make every reasonable effort to minimize any loss, damage, or liability, and take appropriate emergency measures immediately if they're required to reduce any claim. Now, here, an insured will be under an obligation to minimise their losses, which may mean branching out into other areas of work, carrying on other types of business. Is it right that that should be held against them, because then they would not be a complete inability? The fifth point is that Hiscox's construction is uncommercial and renders cover illusory. The reality of Hiscox's position is, as soon as there's some use of the property for the business purposes, then there's no indemnity. That cannot be right, and is contrary to all the well-known authorities on this point. For example, Cornish and Accident Insurance, please see D241628, paragraph 57 of our skeleton argument at first instance. And then our sixth and final point on inability to use is Regulation 6. Now, the court's finding was at J270 C3. Sorry, excuse me, just receiving a message. Yes, so this is on Regulation 6. The court found at judgment paragraph 270, which is C3112, that cases in which Regulation 6 would have caused an inability to use the premises would be rare. Now, with respect, that can't be right. First, there was no evidence before the court. But if it's right that Regulation 6 is indeed a restriction imposed, which it is, then there'll be many cases where the Regulation 6 causing an inability to use would not be rare at all. So, for example, an accountant using the office and going in only to look at confidential documents, well, realistically, that is an inability to use, and that is the effect of Regulation 6. I've got, with my one last minute, I just turn to our ground 2, just to make some very brief points. The first point on, and this is our ground 2, which addresses the restrictions imposed. Just on restrictions imposed, if I could please ask the court to draw a parallel between the current lockdown we are in and the lockdown that we were in. The difference here is that the Prime Minister announced the restrictions on the 31st of October and had time to bring into effect the relevant regulations by the 5th of November. The situation in the first lockdown was more desperate and more urgent and more worrying, yet that on Hiscox's case would not be a restriction imposed. And that is an unrealistic construction, we would suggest. My lords, my time is up. Unless I can assist your lordships further, those are our submissions.
Thank you very much, Mr. Lynch. Well, we adjourn now for 5 minutes, and then we'll resume to hear the reply by the appellant insurers. So we turn now to the insurers, and I think we're beginning with Arch Insurance, represented by Mr. Lucky.
Good morning, my lords. In my 30 minutes, I have to deal with ground 3 of the FCA's appeal, my reply to the FCA's response to Arch's appeal and causation, and thirdly and finally, my response to ground 1 of the FCA appeal. So if we can start with ground 3 of the FCA's appeal, that seeks to extend against Arch very considerably the number of policies which have been triggered. And as I explained to your lordships on Tuesday, the court below accepted Arch's case as to what triggered the extension 7, the GLAA clause, and for which categories of business at paragraphs 309 to 336 of the judgment. And we fully support and endorse the reasons given by the court in those paragraphs. As your lordships will have seen, the court below engaged in a careful exercise of construing and then applying the extension to the various categories of business in light of the advice issued and the actions taken by the government, all of which advice and action was also closely examined by the court below during and no doubt following the 8-day trial. The court also considered the various theoretical examples raised by the FCA, along with some others. But rather than answering those hypothetical questions, the court addressed the facts and produced the judgment, which we say is plainly correct. The FCA does not suggest, and Mr. Edelman did not suggest, that there were any relevant principles of construction which were misapplied by the court. He doesn't like the result, but there's no suggestion that the court below applied the wrong principles. And in those circumstances, we suggest that this court should be very slow to interfere with the judgment of the court below on those issues. And I do make the point that the FCA's case does not really engage at all with the court's reasoning as set out in paragraphs 309 to 336 of the judgment. Now, we have responded in some detail to ground 3 in our respondents case at B tab 12, page 534, and I'll have to take that as read. My lords, the GLAA clause, just to remind you, C tab 4, page 227, requires that the relevant action or advice prevents access to the premises. And can I make three fairly obvious points? Firstly, access to the premises is plainly a reference to the means by which entry or approach is made to the premises. That was common ground below. It's set out at paragraph 315 of the judgment and is obviously correct. So the relevant inquiry is as to the effect of action or advice on the means of accessing the premises. The inquiry is not into the effect of government action or advice on the movement of people or on who may enter the premises. The second obvious point is that prevent is a word with an ordinary meaning, stopping something from happening or making something impossible. And in practical terms, in the context of the subject matter of this litigation, nothing short of action or advice requiring closure will prevent access to the premises. The clause plainly does not contemplate a partial prevention of access, and we remain puzzled about how there can be a partial prevention of access to the premises. Either access to the premises is prevented or it's not. The clause is not concerned with limits placed on the uses to which the premises are put or on who may access the premises and for what purpose. The third fairly obvious point is that other provisions in the same policy confirm that our reading of the GLNA clause, which was accepted by the court below, is correct, and that nothing short of closure is required on the facts of this case. Yes, my lord.
There has to be some inquiry, doesn't there, Mr. Lockie, into who can access the premises and for what purpose. Otherwise, there'll be no cover unless the premises were sealed off to anybody and nobody could get into them for anything at all. I mean,
No.
that just can't be right. If somebody lives above the shop and they come in through the door, they're not prevented from access to the premises, and yet you, I hope, wouldn't say the clause didn't apply if the shop is closed.
No, my lord. We accepted in the court below, and we accept obviously here that the prevention of access refers to access for the purposes of carrying on the business at the premises.
Well, fine. Well, then once you accept that, why can't you divide it up into different businesses carried on at the premises?
Well,
And if the food hall is open, but the rest of the shop which sells clothes is closed, there's prevention of access to the part of the premises.
the policy defines the business by reference to the terms in the schedule, and therefore, for the purposes of the prevention of access clause, the relevant access is to capitalized terms the premises, which is referred to elsewhere and defined elsewhere as being the place where the business as defined in the schedule is carried out. And therefore, those are defined terms, my lord.
Well, that doesn't mean that you can't have a prevention of access to a part of the premises. The whole encompasses the part. Or that you couldn't have prevention of access for one business activity, but not for others.
No, my lord, we would, with respect, disagree. It is simply a binary question by reference to the single defined premises, or in certain cases, that there will be multiple defined premises. It's the means of accessing those single premises which must be prevented.
Or a word about the business activities, which aren't even mentioned in the clause, so you have to read in something about that anyway.
Well, that's because the premises are defined by reference to, the business is defined by reference to the premises, and we accept there has to be access to the premises for the purposes of carrying on the business, because, for example, if one takes the situation of a bomb scare and where the premises are required to be shut off, the fact that someone might be able to go in simply to switch off the electricity does not mean that there's been a prevention of access to the premises. But subject to that qualification, in our respectful submission, the clause is simple, straightforward, and provides essentially a binary yes-no question. Are the means of access to the premises stopped or not?
Well, it's very simple on your construction because it produces unreasonable results. It shuts out everybody. So in the takeaway example, it seems totally unreasonable to say that there's no prevention of access for the purpose of dining in the restaurant, just because you can carry on a takeaway business. There's nothing to stop you separating those activities, is there, in the clause?
Well, my lords, the clause is concerned with the means of accessing the premises, not with the use to which the premises are put, which is a concept which is dealt with explicitly elsewhere in the same policy. Mr. Edelman showed you extension 3 on the preceding page.
Well, then it shuts out the repairman from coming in.
I'm sorry?
Then it shuts out the repairman from entering because there isn't complete prevention of access for everybody for all purposes.
For the purposes of carrying on the business, there is. Where there is an existing takeaway business at the premises, and the business is allowed to continue after the closure order to continue that business, it is in our respectful submission, inconsistent with the very plain meaning of the language used in clause 7 to say that there is a prevention of access to the premises for the carrying on of the policyholder's business, which included the takeaway. The fact that part of the premises where one dines in can't be used does not affect the means of access to the premises. The premises remain fully accessible. It's just that the use to which part of the premises may be put is impeded, and that is dealt with not by clause 7, but by clause 3. Clause 7 only applies where the means of access is prevented.
I hear your submissions, they say.
Well, my lord, you've already seen extension 1, Mr. Edelman showed you, which refers to restrictions, which refers to hindrance or prevention of access. And obviously, prevention of access, when used again in clause 7, must have the same meaning as it has in extension 1, and therefore cannot include hindrance of access. So far as extension 3 is concerned, as I said, that draws a clear and obvious distinction between prevention of access to the premises on the one hand and restrictions placed on the use of those premises on the other. And my lords, the FCA's case involves the somewhat remarkable proposition that there is a prevention of access to the premises for businesses in category 3, essential retail businesses expressly permitted to remain open by the regulations, and category 5, businesses which were not required or advised to close their premises. And the argument is that there's at least a partial prevention of access to those premises because of Regulation 6 or the social distancing guidance or the 16th of March advice of the Prime Minister. But again, that proposition only has to be stated for it to be seen to be wrong. Regulation 6 did not have any impact on the means of accessing category 3 and category 5 premises, nor did the social distancing guidelines, the 2-metre rule, or the 16th of March advice. And the FCA's argument becomes even more absurd when one appreciates that Regulation 6 was itself subject to exceptions, which permits people to attend category 3 and category 5 premises. For category 3, essential shops, employees and owners were able to access the premises, as were customers. The FCA's case that during the first lockdown, there was a prevention of access to the premises of Tesco because of Regulation 6 or social distancing guidelines or the Prime Minister's advice on the 16th of March is truly absurd.
Well, an example that's not so absurd would be a shop such as Boots, which was allowed to continue trading because they had pharmacies. But the areas that were selling cosmetics, for example, were closed off and unmanned. If they'd run two separate shops, one containing the pharmacy and the other containing the cosmetics, then obviously the cosmetics shop would have been closed and they'd have recovered under the policy. As it is, because they had one single outlet, the public access continued to be outlet, but people could only shop for the essential items and the rest would be barred by chains or whatever to stop them going into those areas of the shop.
An excellent example, my lord, of restrictions placed on the use of the premises. But Clause 7 is concerned with prevention of access to the premises, the means of accessing the premises, which in your lordship's example is not prevented.
Yeah.
My lords, then if I can respond briefly to the FCA's response to our appeal on causation. Arch is only concerned with causation and the trends clause at the stage of quantification of loss, where our extension has been triggered. We're not concerned with issues of causation arising at any earlier stage, at what Mr. Edelman referred to as the primary causation stage, which is an issue for the disease clause insurers. Can I return to the example given by Lord Briggs on Tuesday, day 2 at page 145? The travel agent whose turnover reduces dramatically because no one is buying holidays in the period before the travel agent is required to close its premises. Mr. Edelman seemed to inclined to accept that on that example, the losses in question were not access related, and we say quite right. But this shows that there is something wrong with the FCA's position on the counterfactual, and indeed also with the FCA's appeal on ground 1. And that's because the FCA's case, as you'll remember, is that once the insured peril is triggered and the remaining conditions satisfied, all the effects of the underlying elements, including therefore in Arch, the emergency, are included in the indemnity. And that would include, on the FCA's case, losses which are not access related. And we would submit that calculating the travel agent's loss for the period of closure from the end of March to July 2020, by reference to the 2019 turnover, without taking into account the losses which would have been suffered even if the premises had been permitted to remain open, does indemnify the travel agent against non-access related losses. And the Mr. Edelman's, albeit tentative, response to the travel agent example demonstrates in our respectful submission why the FCA's argument that trends clauses are confined to extraneous matters cannot be right, because the emergency which has led to what he has referred to as the non-access related losses is not, on the FCA's case, extraneous to the peril. Yet Mr. Edelman appears to accept that non-access related losses are not covered. And our objection to the declarations made following the trial below is that they prevent us from arguing that all or part of the loss of turnover during the period of closure, measured by reference to the same period in 2019, would have been suffered in any event, even if the premises had been allowed to remain open, by reason of the economic effects of the pandemic, the stay-at-home regulation, and the social distancing guidance, none of which are insured perils, and that these are losses which are not access-related losses. Can I remind you in this context of Agreed Facts Document 8, which is relevant on this issue, and indeed to the court's consideration of ground 1 of the FCA's appeal. This was one of the sets of agreed facts for the trial. Bundle D tab 12, page 1545. So these were assumed agreed facts, and I just invite you to cast your eye. I'm not sure you've been referred to this specifically before. If I could invite you to cast your eye over paragraphs 1 to 3, I don't have the time to go through this, but those are important points to bear in mind, that they are agreed facts. So, my lords, turning to the Archer's case on but-for causation, we say that but-for causation is positively required at the quantification stage by the Arch trends clause. One removes the peril, no more and no less. We submit that proof of but-for causation is an essential element of showing that losses have been caused by the insured peril, a point made in Orient Express at paragraph 58 of the judgment of the Commercial Court, and if necessary, the presence or absence, the presence of the trends clause is not crucial. But we don't need to succeed on that argument because the trends clause provides the test anyway, which clearly applies at least at the quantification stage. I appreciate there's a debate that may be relevant for the disease clause insurers in relation to the operation of the peril. But certainly at the quantification stage, which is the only stage relevant to Arch, the trends clause applies. Now, my lords, the FCA has sought to persuade this court that there are implied restrictions on what can qualify as a trend or circumstance, even though the Arch trends clause requires reference to any trend or circumstance. And on day 2, at page 136 of the transcript, Lord Amlin asked Mr. Edelman to explain how, as a matter of construction, the trends clause may be read so as to exclude as a trend or circumstance something which is connected to the peril, and to limit trends or circumstances to extraneous things in the world which would have affected the business. And we respectfully submit that the FCA has no satisfactory answer to that point. The FCA's reading of the trends clause seeks to insert qualifications or limitations which are simply not there. There was a reference to the Hiscox book and the suggestion that there was some settled meaning of the trends clause amongst loss adjusters, at least prior to 2010, when Orient Express was decided, some alleged settled meaning or practice which was not known to the 3 members of the tribunal in Orient Express, one of whom was an insurance market practitioner, nor to the court, nor to the parties, nor to their advisors, and nor presumably to their experts. And this settled meaning is supposedly that the trends clause does not include something which is connected to the peril. And the suggestion is that Orient Express was decided in ignorance of that settled meaning or practice. But in our respectful submission, the Hiscox extracts which have been shown do not bear anything like the weight which Mr. Edelman sought to place on them. Hiscox is not a legal test. The book doesn't appear to have been referred to in any of the cases. It doesn't form part of the admissible factual matrix, and it doesn't represent admissible evidence of market practice. And more generally, Hiscox is concerned with the position where wide area damage, as well as damage to insured property, is caused by a storm. And certainly for prevention of access clauses, such as the Arch clause, there is no wide area damage analogy which can sensibly be drawn. One could only draw the analogy if one made the elementary mistake of assuming that in our case, the disease is the peril, but it's not. Our peril is prevention of access to the premises, not the disease. And therefore, our trends clause requires the application of a but-for test to exclude the non-access related effects of the disease. In other words, the effects which would have been suffered if the premises had remained open. Finally, in my allotted time, a few minutes on responding to ground 1 of the FCA's appeal. And this obviously does not arise if Arch has succeeded on its appeal. I think that is common ground. Ground 1 is an attempt by the FCA to extend the impact of the counterfactual case which prevailed in the court below. And in his submissions, Mr. Edelman ran grounds 1 and 2 together, but ground 2 does not apply to ARCH, because as you know, the ARCH clause is triggered by government advice recommending closure, as well as government action requiring closure. And therefore, we do invite the court to treat ground 1 separately from ground 2 and not to allow the FCA's points on ground 2 to cloud the analysis on ground 1. I don't have time to invite you to look at the declaration, the subject of ground 1 of the FCA's appeal. It's at C tab 1, page 7, and it's paragraph 11.4c. There's no appeal from 11.4a or b. Declaration 11.4c, the one that's challenged by ground 1, refers to a measurable downturn in turnover prior to the operation of the insured peril. And we submit that assuming that there is a measurable downturn in turnover prior to the operation of the insured peril, Declaration 11.4c is correct in principle, and that we are entitled to take that into account when adjusting claims. A measurable downturn in turnover caused by the emergency in the weeks before the operation of the insured peril is plainly a trend which has affected and is affecting the business before the operation of the insured peril, in our case, the government action or advice requiring closure. And one can test this again by reference to Lord Briggs's example of the travel agent. It would offend common sense, of which Mr. Edelman professes to be so fond, as well as contradict the terms of the trends clause, to suggest that the downward trend before the insured peril operates should be ignored. It would offend common sense and be contrary to the trends clause to allow the travel agent to recover its 2019 level of turnover whilst it's closed. The downward trend pre-peril is therefore a trend which on the face of the trends clause plainly should be taken into account when adjusting the loss. It means that the loss, once the peril occurs, is assessed by reference to the actual experience of the business at the commencement of the indemnity period, whereas on the FCA's case, the loss is to be measured by reference to a completely notional pre-indemnity period experience of the business. That is not sensible, and it is not what the trends clauses provide for. We made the point in our written. I'm sorry.
It seems to me there's a sort of false battle going on here. As I understand it, you and Mr. Edelman both accept that if the pre-trigger downturn in relation to a prevention of access clause is some other economic consequence of the pandemic, then it doesn't get stripped out of the counterfactual. I think that's Mr. Lockie's concession by reference to the travel agency example. But if the pre-trigger downturn is in fact an access-related downturn, in other words, it's the chilling effect of COVID on people coming to the premises in advance of a government restriction, then it should be stripped out of the counterfactual. That seems to be what Mr. Edelman is suggesting. And I just wonder whether the difference between you isn't more about how you draft a declaration which captures that distinction, rather than one side saying you strip out COVID for all purposes and the other side saying you don't strip it out for any purposes.
Well, my lord, I'm running out of my allotted time, so I'm not going to be able to respond in full on that. What I would respectfully suggest is that Mr. Edelman's suggestion or concession, if such it be, undermines completely his case on the trends clause, because on any view, the emergency is not, on his case, extraneous to the insured peril. Anyway, I'm afraid I have to pass on now to the next insurer in line. I would like to assist your lordships further, and I'm sure I could assist your lordships further, but time doesn't permit, and obviously I have to rest on my written documents.
Yes, we understand. Thank you, Mr. Lockie. I think we turn next to Mr. Gazeman.
Am I visible? And it will. Need to hold that down a bit more. My Lords, I have 20 minutes. First, the Hiscox appeal, 3 short topics. The first one is Hiscox 4, judgment, paragraphs 112 and 418. Members of the court have asked questions about whether the analysis in 112, the thousands or millions of proximate causes, should be adopted, and others will address that. But as your lordships know, as regards Hiscox, there is a specific reason why it should not. As I mentioned in opening, we have a clear finding in our favour in judgment paragraph 418. Now, my learned friend for the FCA gave an answer on day 3, pages 84 to 5, to my Lord Hamlin's question about this paragraph, to the effect that all the judges were saying in 418 was, well, and I quote, if you have all these pins on the board, if you take one pin out, it's not going to make any difference, unquote. My lords, they were not saying that. They were saying that what occurred within the 1 mile radius was simply not causative of the restrictions. And the court was accepting the submission which Hiscox made, which they recorded at the end of judgment paragraph 403. And there is a further point in relation to this. Judgment para 112 is reflected in Declaration 10, C1, page 6. Now, your lordships do not yet know, but I'm telling your lordship now, that there was a dispute between the FCA and Hiscox after the consequentials hearing about whether Declaration 10 should or should not include Hiscox 4. That dispute was referred to the court, and the court ruled in Hiscox's favour. That is why this declaration does not include Hiscox and is confined to the disease clauses. The second topic is but-for causation and Hiscox. Now, again, others will address this topic more generally, but as regards the Hiscox wordings, there is no issue, or there was no issue, that one applies but-for reasoning both to the main insuring clause and to the counterfactual, and to the trends clause. The court below so held in the most unequivocal terms in paragraph 278. Nowhere has the FCA complained about that holding or criticised or said the court was wrong in that paragraph. But if it is now said, as regards some insurers, that but-for causation should in some way not apply, that cannot be so for Hiscox, not only for the reason just given, but also because the Hiscox policies only insure against loss, quote, solely and directly caused, or solely and directly caused by interruption, which is D in my chain A, B, C, D. And that interruption has itself, of course, to be caused by A, B, C. This is our ground of appeal 4. I mention this point now, although it's in our case at paragraphs 97 to 100 of our appeal case, because I had thought that this appeal was proceeding on the basis of judgment paragraph 278. And as we pointed out in our appellant's case, paragraph 26, the FCA explicitly stated below that it was not seeking to disapply but-for causation. But the words solely and directly put this issue, at least as regards Hiscox, beyond dispute. The FCA's Respondents case para 224.1 accepts that the word solely and directly imposes a stricter test than proximate cause. The effect of such a provision was considered by my Lord Hodge in the McCann's Executors versus the Great Lakes. Just for the reference, we haven't got time to look at it, E3431196. See especially paragraphs 16 to 17, 25 and 28. And the effect in that case, and generally, is that where a loss is concurrently caused by 2 proximate causes A and B, but the policy only insures against loss caused solely by A, there is no cover. So the effect of this provision is to cement the but-for test in the analysis. and the words solely and directly make any debate about but for and other possible proximate causes irrelevant, because only losses solely caused by an interruption itself caused by ABC are covered. And that applies both generally, but also to the causation issue within the coverage question on Hiscox 4. Thirdly, and finally on the Hiscox appeal, the role of the disease in the counterfactual. My lords, the FCA continues to say that it finds our case on this incomprehensible. We illustrated it in our appellant's case, paragraph 53, with the pipeline example. The point is simply this: Hiscox's indemnity does not extend to the uninsured effects of the disease, represented in that example by pipelines X, Y, and Z. But that sounds axiomatic. We don't insure uninsured effects. But that is what is meant by saying that the disease is removed insofar as it causes the restrictions imposed. And it really comes down to 2 points, my lords, which I would like to leave with your lordships on this. First, what is your lordship's judgment on our 13th chime point? Perhaps that's a slightly question-begging way of putting it, but it identifies the point. How can a public authority clause require underwriters to indemnify in respect of losses not caused by public authority restrictions? That's the first question I leave with your lordships. And the second question I leave with your lordships is this: who is right on this question? Is this an insurance against rats or drains, etc., or disease, provided only that there is public authority action? Or is this an insurance against certain consequences of public authority action, provided that the reason for that action is one of the causes stated in clauses, subclauses A to E? If we are right on that question, and my learned friend said very little about that debate, if we're right on that, it cannot be right to remove anything wider than the consequences of the public restrictions caused by the disease. My lords, I turn to the FCA's and TAG's appeal. Restrictions imposed. Now, my lords, listening to my learned friend Mr. Edelman's through the looking glass submissions yesterday, one might have forgotten 3 things. First, the question is, what is the true construction of the words, quote, inability to use due to restrictions imposed, close quote, in Hiscox 1 to 4? Do they refer to legal restrictions imposed or something wider, and if so, what? Secondly, this question is to be viewed as at the date of the contract. It is a question of the parties' original intentions. Obviously not with the benefit of hindsight. One doesn't start, as my learned friend did, with the Prime Minister's 16th of March speech, ask which bits of it were mandatory in the special coinage that the FCA gives that word. And thirdly, the concept of mandatoriness is nowhere in the contract, save in its usual sense, meaning that which is either required or prohibited by law. Now, my lords, and nothing that my Lord Legate said in Equitas, if I may respectfully say so, requires one to do other than examine the presumed intention of the parties as at the date of the contract. Now, let's go back to that point. The idea of the government ordering people what to do in a non-legal way would not have been familiar to the contracting parties, nor would the concept of restrictions imposed other than by authority of law. If someone had asked the parties at the time of contracting, do you contemplate the possibility of restrictions imposed by a public authority causing an inability to use other than by operation of law, I respectfully suggest that their answer would have been, of course not. What sort of a country do you think we live in? Or, to use the language of Lord Hope in the Lloyd's TSB case, the meaning that my learned friend Mr. Edelman puts on these words is a meaning that no reasonable person would have dreamed of giving them at the time. It is common ground that the wordings in this case should be, the meaning of the wordings themselves should be clear and readily applicable in the real world. The court below provided a readily comprehensible test. I respectfully suggest that policyholders and insurers would be utterly bemused by the FCA's proposed test, which actually has been introduced in order to deal with a completely different concern which the FCA has about the interaction of this point with the trends clause. The test between what is permitted by law and what is forbidden by law is not only a readily comprehensible test, it is one that every inhabitant of this country has to live by every day of their lives, insured or uninsured. This has got nothing to do with insurance. Everybody under the present lockdown has to know what they're legally prohibited from doing. My lords, I hope it's not too old-fashioned to engage in a little bit of textual exegesis, although there was not very much of it in my learned friend's submissions. The words are restrictions imposed, producing an inability to use. Whatever the ambit of the inability that the insured must prove, I leave that as a separate point, it has to be an inability. Now, restrictions that do not have the force of law do not create an inability, because compliance is a matter of choice. In our country, an insured may do what it likes with its premises, and if it's unable to do that, it's because it is prevented by law from doing so. My lords, social responsibility is a laudable thing, but it cannot create an inability to use. And similarly, perhaps I don't need to apologise, I almost feel I do, for looking at the natural and dictionary meanings of the words used. We all know what imposed means, and it's not an accident that it does. As we point out in our respondent's case, the fact in the clause that the imposer is stated to be a public authority that has legal power, that has power to impose the stated restrictions, refers to the, my lord.
No doubt right, Mr. Gazeman, that nobody at the time the policy was drafted expected that the Prime Minister would come on television and order people to do things without, at the time, a legal basis for that. But it's unrealistic, isn't it, to expect the policyholder who watches that broadcast to say, oh, well, it's all very well for you to say that, Prime Minister, but unless and until the law is changed, I'm going to carry on business as usual. That's just an unreasonable way to expect a policyholder to react.
Well, my lord, there are two views about that. A struggling business that needs all the income it can get would not, I respectfully suggest, be open to criticism for staying open until it was required to close. But in any event, my lord, the question is what has to attribute a test to the parties, an intention to the parties as at the date of contracting. And if the natural intention at that stage would be to distinguish between what is required by law and what is not required by law, as I suggest it would have been, then that test is what carries forward into the future.
But it's not right to proceed on the basis that the parties wouldn't have thought of this situation, therefore it's not covered. You have to take the situation that has happened, the broadcast that is made, and say, what should the parties be taken to have intended the words to mean when applied to this situation, which has occurred.
Well, my lord,
You say your approach is consistent with what Lord Justice Chadwick said, but it seems to me it's not.
well, it's consistent, my lord, with what Sir Thomas Bingham said, and the difference between the implication of a term and the matter of construction is an irrelevant difference when it comes to the extent to which you interpret the contract in the light of events which has occurred. But all I would do, perhaps in the limited time I have, is to quote to my Lord Legate what my Lord said yesterday at page 134, because, in a sense, I'm moving on to a slightly different question, a question of practicality. Your Lordship said, if we were to rule that the Prime Minister's statement was mandatory, that might be a bit too broad, without looking at particular language of particular parts of it, and looking at particular effects, or how they might reasonably be understood by particular business sectors. Now, this is not the stuff, this speech, my lord, of the clause at all. Let me give your lordship two examples taken from the Prime Minister's speech. The only mention of restaurants in the Prime Minister's speech on the 16th of March is London restaurants. Is this a mandatory statement as regards restaurants not in London? What is London? Second point, some businesses subsequently ordered to close were not mentioned at all in the Prime Minister's speech on the 16th of March, such as beauty salons. So we have a situation whether restrictions were imposed on the 16th of March depends on this Prime Minister's notorious taste for euphony. Now, these are totally quixotic results, cannot possibly have been intended, even if one attributes the generous dollop of hindsight, which I very respectfully suggest is being posited. Then we have another issue, my lord. The reasonable impartial observer. Because somebody's got to work out not what the law is, which everybody has to do, but what something means. We have to parse the modal verbs. We have to cope with the fact that different ministers may say different things on different days in different language. And we have to accept that the libertarian and the valetudinarian will have a completely different approach to the question of what something either means or should be taken to mean. And although I understand the circumstances in which the first lockdown was imposed, I do very respectfully urge that taking too narrow a view of what is socially responsible, without recognising that people are entitled to do that which they are not legally prevented from doing, would be a mistake. Because in fact, what your lordships are, or what my lord, in a sense, Lord Legate is putting to me, is that the contract should be interpreted in a way which ascribes a legally inaccurate understanding of the position to the parties. Because if the parties had understood the position correctly, they would have realised that there were no restrictions imposed by law. My lord, I see that in my enthusiasm to answer your lordship's question, I've practically done myself out of my remaining time. But all I think I can do now, I need to move on to inability to use, but we've managed to debate inability to use over 2 days, some part of 2 days, without actually looking at what the judgment below said on this. And it's paragraph 268 at C3112. And this is what this appeal is about, my lords, on this point, because the judgment on this paragraph, which I have a particular pleasure in quoting since it reflects the submissions that we made below, unlike some other paragraphs, and this is what this is about. Did the judges below get this wrong? Now, if I had time, which I don't, I would read this paragraph to your lordships, and I would commend it to your lordships, because a great deal of the target that my learned friends have been aiming at has been the wrong target. All I am seeking to do is to uphold this paragraph of the judgment. And Lord Mustill always used to say that if you asked a rhetorical question, you were in danger of getting a rhetorical answer. So I will avoid that and simply say there's nothing wrong with paragraph 268. Lords, I think I'm out of time.
Thank you very much, Mr. Gason. And now I think we're going to hear for the first time from Mr. Orr on behalf of Zurich.
That wasn't. Yeah.
My lords, can you see me and hear me?
Yes, perfectly, thank you.
My lords, I have 15 minutes to present Zurich's submissions. Zurich is concerned only with two of the FCA's grounds of appeal, namely the force of law and total closure points. That is grounds 2 and 3. There are two Zurich wordings in issue. They are in materially similar form. They are both prevention of access wordings. Could I take your lordships to that wording as it appears in the Zurich 2 policy? That is the policy that is quoted in the judgment. It is at C tab 19, page 1448. Lords, and if I can start about a quarter of the way down, your lordships will see the stem wording, additional cover extensions applicable to subsection B1, business interruption, all risks. Any loss as insured under this section resulting from interruption of or interference with the business in consequence of, and then it's little b, any of the undernoted contingencies will be deemed to be an incident, and as an incident within the scope of cover. The first extension is the action of competent authorities clause. This is the extension which is the subject matter of the FCA's claim against Zurich. We describe it as the AOCA extension. That's how it was referred to below. The key words, your lordship see, are action by the police or other competent local civil or military authority following a danger or disturbance in the vicinity of the premises whereby access thereto will be prevented. There are two other extensions which are relevant to interpretation of the AOCA extension. First, on the next page, that's 1449, the notifiable diseases extension. Your lordship see there the description of the contingency, loss resulting from interruption of or interference with the business at the premises resulting from various matters, including the occurrence of a notifiable disease at the premises, which causes restrictions on the use of the premises on the order or advice of the competent local authority. The second extension that I want to draw your lordship's attention to is the prevention of access extension on the following page, 1450, and there the contingency is described as property in the vicinity of the premises, damage to which will prevent or hinder the use of the premises or access thereto, whether your premises or property therein sustain damage or not. And your lordship will note the draftsman's use in those two further extensions of the phraseology restrictions on the use of premises, the phrase order or advice, as opposed simply to action in the AOCA extension, and the reference to matters which hinder access to premises and matters which prevent or hinder the use of the premises. Now, my lords, the court below found that the AOCA extension did not respond to the measures introduced by the government in response to the COVID-19 national pandemic. The court found that the AOCA extension provided narrow, localized cover intended to cover dangers occurring in the locality of the insured's premises. The court concluded that this cover was not triggered by the government action responding to the national pandemic, because that action was not caused by, and hence did not follow, any danger or disturbance that was specific to the locality of an insured's premises. That conclusion is not challenged by the FCA. The FCA's appeal will not therefore affect the outcome of these proceedings against Zurich. The FCA has nevertheless chosen to appeal the court's findings as to the meaning of the terms action and prevention of access in the Zurich wordings. And I turn to those points now. I deal first with prevention of access. The court found
Sorry,
that access to...
Can I just ask?
Yes, my lord.
Does this point have any bearing for the real world because of some other situations that arise, or is it just an abstract question that we're being invited to decide to add to all the other important real questions?
My lord, so far as Zurich is concerned, it is abstract. The phrase prevention of access appears also in Archer's wording, and I will come to that. So it has effect in relation to another insurer's wording. So far as the meaning of the word action is concerned, I think I'm right, but I will be corrected if I'm wrong, that is purely academic, in that it appears in the Zurich wording and also in MS Amlin's MSA1 wording. But again, that wording is wording in respect of which the court below found in favor of MS Amlin. And again, the FCA, I think I'm right in saying, doesn't actually challenge the outcome of the case in respect of that particular wording. So, my lord, so far as action is concerned, the short answer to your lordship's question is yes, and indeed that is a reason that we would pray in aid for this court to be cautious about overturning the court below's decision on the meaning of action, at least as it applies in relation to the Zurich policies. My lord, so far as prevention of access is concerned, the court below found in relation to the Zurich wording that access to premises is prevented where the premises have been totally closed for the purposes of carrying on the insured's business. And as in the case of Arch, in the context of the Zurich policies, the business in question is the business stated in the policy, that is the insured's pre-existing business. Zurich submits that the court's construction of the phrase prevention of access is correct. The FCA's contention that partial prevention should also count as prevention of access is wrong, we submit. And on this issue, we gratefully adopt the submissions made by Mr. Lockie on behalf of Arch. I make only at this stage the following short points. First, we submit that the language of the AOCA extension is clear and unambiguous. Cover is triggered where access is prevented, nothing less will do. Partial prevention of access may amount to hindrance of access to the premises or possibly hindrance on the use of the premises. However, neither of those suffices for the purposes of the Zurich AOCA extension. Neither hindrance nor use of the premises is referred to in the AOCA extension, whereas they are referred to in the notifiable diseases and prevention of access extensions. The choice of different language in these provisions, should we submit, be taken to be deliberate. The second point I would note is that the construction adopted by the court below accords with the genesis of action of competent authority extensions, such as those found in the Zurich policies. These extensions arose out of terrorist activity in the UK in the 1980s and 1990s, which involved devices that did not explode, not just those that did explode, so that traditional business interruption cover contingent on property damage did not respond. That is explained by Riley on business interruption insurance in a passage cited in the judgment at paragraph 489. So the paradigm situation contemplated by these extensions is one where a potentially dangerous situation, such as a bomb scare or other incident, requires the police or other emergency responders to cordon off or otherwise prevent access to premises that are believed to be dangerous. In this regard, it should be noted, my lords, that police cordons have the force of law, As the court below correctly observed, individuals other than those permitted to go through a cordon, such as emergency workers, would break the law if they went through the cordon. A police cordon therefore constitutes a legal as well as a physical barrier to accessing premises that are within the cordon. My Lord, I note the time.
Yes.
I could finish off prevention of access before lunch.
I think it might be better if we were to adjourn just now, and we can sit again at 2 o'clock.